Can I ask a clarification on this specific case?
Yes.
Bank of America filed this. It wasn't the holder when it filed, but like 9 days later or something, it was assigned, correct?
Well, there's two parts to having standing to file a foreclosure.
Okay.
One is you have to have the note, and the note when they filed the complaint, and in fact the record still shows that the time the judgment was entered, the note was payable to Wells Fargo. It was never payable to Bank of America. And the note, they did do an assignment of the mortgage to Bank of America, but that's really only half of the puzzle.
Okay.
So even at the time of the summary judgment, there was no standing on the part of
So Wells Fargo was still holding the note at that
holding
point?
the note, yes. And
a year later? Was it?
Yeah, a year and a half later, roughly. Yes. Yeah.
How does that just seems really odd. How does that happen?
And that's part of what this case is about. I mean, the courts need to take seriously their responsibility to take a look at a case, independent of what the litigants do, and decide whether that the court properly has the right to exercise jurisdiction in the case. You know, to some extent, you have to take you have to make. And I'm hoping the court will give some direction to the judges in the state that it's their obligation. The power of whether to hear a case or not under Ohio's Constitution really is in the hands of the judge, not the litigants. What the parties do is much less important.
If the Supreme Court sides with you, are we really going to see? I mean, are we looking at tens of thousands of cases that are like this?
Look, most people, once they're at a point where their house is being foreclosed on, there are 1,000 other issues in their life that are concerning them. The least of which is who the right person is suing them. In certain circumstances, however, where people have had defenses and had the ability to defend a case, and they were unable to do so, I think it will be life-saving for certain people who, and for many people who, it's very well known nationally how difficult people have had. I had somebody call me yesterday. They submitted documents to their loan servicer 33 times, and they keep asking them to resubmit. So people who have a job or who have recovered from whatever infirmity caused them to fall behind on their mortgage and want to get back on track, this would be a lifesaver for people like that who could then have a chance to keep the ball alive in court, bring everybody back to the table. And frankly, with some of the motions we vacated related to the Schwartzwald case around the state that we filed, that's exactly what's happened. We've brought the lender back to the table. We've shown them that the court made a mistake in granting the jurisdiction to begin with, and then we've gotten to the table and worked something out so people could stay in their homes. So I think there is a line to draw at some point here, and I tried to make that clear to the court. I'm not looking for chaos. What I'm looking for is but the fact is that the Constitution really does protect you. Somebody who doesn't have a complaint against you shouldn't be able to sue you.